Hi, I'm Andrew Mishlove. This is my video series, How to Win a Drunk Driving Case, a guide for the layperson. And we're talking again about the 7 key factors in drunk driving defense. In this session, we'll talk about the 4th factor, which is your driving. Now, sometimes it's obvious when a person driving is impaired. We've all seen situations where a person is swerving all over the road or doing things that are very dangerous. And if that's occurred in your case, it's a real problem for you. But most of the time, when people are stopped or arrested for drunk driving, it's because of something else. It might be a taillight that's out. It might be what the police call weaving within the lane, which I think is just normal driving. It might be because of some minor violation like a wide turn or speeding 5 miles an hour over the limit. The fact is that when it gets late at night, close to midnight or the early morning hours, the police will pull you over just because of the time of day and because they think that anybody who's out at that time of night has been drinking. So if you've been accused of drunk driving, you need an attorney who knows how to evaluate the driving very specifically to determine whether it really represents impairment. Now, the National Highway Traffic Safety Administration has a list of 20 driving behaviors that may be evidence of impairment. Speeding, for example, is not on that list. It may also be that the police followed you for miles and miles and only saw some evidence of impaired driving for 100 yards or so before they pulled you over. So, if you're thinking about whether or not you can defend a drunk driving case, you need to evaluate the driving itself. If it was scary and dangerous, it's going to be hard to overcome that. But if it was relatively normal driving, even if it wasn't perfect, just normal, then I think the state has a real problem in proving that you were impaired.